Good morning, everyone. Welcome to our webinar this morning. This is our fourth presentation in our series on data security. My name is JP Harris. I want to thank you for joining us. I want to let everyone know we will be recording this session, and we will be taking questions. We'll try to answer as many as we can at the end of the presentation, so please use the Q&A button on your Zoom interface. As I mentioned, today is our fourth presentation. If you missed any of the prior three, you can find them on our website. We started on October 15th with a discussion about new issues raised by our remote workforce. On the 22nd of October, we spent a session on cyber insurance. And last week, we talked about privacy law compliance and risk assessments. Today, we're going to talk about vetting vendors and vendor management to mitigate the risks associated with third parties that access your data. And we're going to take a break for Thanksgiving, and we'll come back on December 3rd, where we'll spend a whole session talking about hackers and their techniques and ways to mitigate those risks. Wanted to give one other plug before we move on. We have part 2 of the firm's employment law seminar. Will be on November 19th, a week from today. It's complimentary. You can register for that on our website. So we'll do some brief introductions. Again, my name is JP Harris. I'm a litigator here at the firm and co-chair of the Data Privacy and Security Group. My role with respect to the group is to counsel our clients through data incidents and breach events. I sort of work backwards from lessons learned there and try to help companies get themselves prepared and have a breach response plan or an incident response plan in place before it happens. I also counsel our companies on record retention and data management to try to cut down on the volume of data that we all need to protect. Doug Verge is the co-chair of our group. Doug takes the primary lead on drafting privacy policies and advising clients on regulatory compliance in this ever-changing world where we have new privacy laws coming on the books. I'm going to pause here and let Tom Mitchell give you a little bit about his background. He'll be coming in with some slides in the middle of the presentation. So Tom?
Howdy, I'm Tom Mitchell. I'm the IT Director, Information Security and Technology Director for Sheehan Finney. I've got a 30-year background in IT, 20 plus in security and management in that respect, with a little Navy career in the background there. So I talk from the perspective of being a CISSP, a Certified Information Systems Security Professional, and that's really the basis for what we'll talk about today again.
Okay, thanks, Tom. All right, here's our poll. For those of you who have been with us before, this is how we try to make sure you're all awake. So here's our poll for today, and the question is, does your company have a written plan to examine security employed by vendors who have access to your company data? So we'll pause here and see who has a plan or who needs a cup of coffee. All right, we'll call it there. Here are the results from we have a couple of people still working on the coffee, which is perfectly fine today. But we've got a good mix. We've got some folks who have a plan already and some folks that hopefully we can help out today. All right, so let's come back to the slides if we can. So let's talk a little bit about lessons learned from others. One of the more famous data breaches in the last several years was the Target breach that caused significant reputational damage, had tremendous business impact on them, not really even accounting for the legal expense. But the source of that breach actually was a third party. It was the HVAC vendor that was the entry point for the hackers to get into the credit card data. And the lessons we're going to talk about here is that you can do all that you can to sort of shore up your own internal defenses, but you have to examine these third parties because if they're weak, your entire system is weak. Just today, there was a headline I noticed before we came online here today that the software provider for Booking.com or Expedia was found to have been storing years of credit card transaction data for years without any protection. But that's another example where if you're Booking.com or Expedia.com, your reputation can take a hit because of a software vendor that you partner with. Blackbaud is a more recent example. I don't know if any of the folks on today's call had any dealings with that, but it affected a good number of our clients in the not-for-profit sector. But Blackbaud is a donor relations management software provider. They were subject to a ransomware attack. Some data was exfiltrated, although Blackbaud reported that the data was encrypted. Blackbaud gave some notice to its customers, right? Its clients, those that licensed the software, but it put those customers in a real difficult spot. They had some information about a data incident that was not of their own doing, but their donors' information may have been accessed by third parties. So it put customers, our firm clients, in a difficult spot to figure out whether they needed to provide notice. There was a real question about whether the data breach statutes across the country had been triggered, but it's another example where you can have some difficulty just because of a third party that you partner with. So why is this more of an issue these days? Well, of course, a lot of companies are moving their data into the cloud, and one of the big selling points for that was, well, you get your data off your own servers, so you don't need to be so worried about protecting your own data. You basically outsource the security portion to someone who's a real professional, and it's their job to stay up to date and to protect your data. So there was a real push, and there's a lot of business benefits to moving your data offsite, but that means partnering with a third party that you don't really control. There are also some vendors that come into your workspace that have really great products, CRM products or payroll and HR, that you therefore enter a portal and share your data, your employee sensitive data with an HR software provider, for example. But their products are better than what you could do on your own. So you're just allowing third parties to have more access to more parts of your data. And then again, what we've sort of reiterated with each one of these presentations is, to the extent that you have more of a remote workforce, you now have more access points. Maybe you've found a software provider to help manage your remote workforce. So vendor management, that's what we're talking about. And these concepts really came down, they started in earnest with the financial sector, but to the healthcare sector as well. So just from a law firm's perspective, for example, if we have clients that are in the financial space, they've had regulators come down on them and require them to deploy security measures, and also to be sure that their vendors are doing what they're supposed to do. So this is a trickle down. It's going to continue to permeate its way through the rest of the business environment, but it's been around for a little while now, and it's just sort of coming into, I guess what I call sort of non-regulated space. There's also, as we talked about last week, an emergence of privacy laws that are giving consumers a lot more rights. And so to the extent that you are required to comply with laws like the California privacy law or GDPR or any of the other variations that are going to be working their way through legislatures across the country, you also are required to make sure that any third parties that access your data are also compliant. Many of these laws require you to disclose to consumers the third parties that have access to your data, and so they're going to know, at least on a categorical level, where their data is going. As we've mentioned a couple of times, the FTC has been actively regulating companies that provide misinformation or overstate their security measures. Just last week, Zoom settled a case with the FTC, and part of that was failure to safeguard information on meetings like this. But also part of it was misrepresenting the extent to which they protected security. So if you are partnering with a third party and they're making grand representations about their security, you need to, this whole point of this presentation is to kick the tires and make sure they're actually following through. And then there's this whole world of new contractual obligations as parties attempt to shift the risk associated with these compliance measures or data incidents. You have to pay a lot more attention to the fine print, if you will, on your contracts. And we're going to spend some time talking about that today. All right, there are sort of 5 basic ingredients to vendor management policies. And what we're talking about now is really a written document, a plan, and a procedure that your company can follow and sort of check the boxes along the way. allocate responsibility internally. But these are the sort of 5 basic ingredients to these plans. Tom's going to talk about the bottom 3 in a few minutes, so I'm going to focus on the top 2 and then turn it over to Tom. So the first sort of basic ingredient, as I mentioned, is to make sure you've got a written plan as to how you're going to select vendors. Now, the business folks are going to be heavily focused, and justifiably so, on the business terms, right? All the great things that this software product can do or the vendor can do for you. They'll certainly be focused on costs and implementation obstacles and all those sorts of things. But what we're trying to advocate for is that you have a dedicated review of the security protocols deployed by these third parties. Tom's going to give you a little more information about how actually to do that, but from the lawyer's perspective, we want to try to help our clients make sure that they've got sort of a written plan. Who's going to do it? Who within your organization has the background to do that? If you don't have it in-house, can you bring somebody else in? I know some companies, when they're vetting, particularly important pieces of software for their business, they hire consultants to help them through that process. If you're going to do that, you want to try to find a consultant that also has some knowledge of the security world. If you have a managed services provider, they may or may not have the skills necessary to help you fully flesh out and vet the security protocols by the vendor, but they might be a good place to start. So step 1 is to have this written plan, identifies the who and the how. How are you going to do this? So we'll spend a few minutes on sort of the second basic ingredient, and that is that there are some legal clauses, sort of contractual clauses you want to keep an eye out for. And it'd be, I think, good if you could have your vendor management plan sort of have a checkbox. You want to try to harmonize these clauses to the extent you can and make them relatively uniform across your vendors if you can, recognizing that you don't always have significant negotiating leverage, but there are some little things you can do here and there, and they frequently, if you can propose some language that's reasonable, you can oftentimes get minor tweaks. In general, what you want to do is try to have as much specificity in the contract as you can have. Know that there's this principle in contract law where you could have, if you're negotiating a contract and you let's say you ask in an email, hey, we're concerned about your security, tell us what you do. And they list out all these things in an email. If those terms don't come into the actual contract itself, they're not going to be enforceable 9 times out of 10. So one of the things to look for is whether there are any promises or warranties regarding security. These days, you'll find them with some frequency, but when you start looking at the actual language, the promises being made can be vague or illusory, right? Sometimes you'll find that they're going to deploy reasonable security, whatever that means, or commercially reasonable security. Sometimes you see this, commercially reasonable security for the industry in which we operate. Sometimes you see this, we're going to deploy the same level of security with respect to your data as we deploy with respect to our own data. So obviously the circumstances are different for each matter. If you're sharing data with them that's not particularly sensitive or doesn't have the kind of personal information that triggers the data privacy laws that we talked about, or don't create significant breach risk, then maybe these terms are fine. But I just want you to pause and think about the kind of quality of data that you're providing to these folks. And if you need more specific measures, things that Tom will talk about in a minute, you want to have them worked into the contract itself. You can't have them live outside the contract because they won't be enforceable should there be a problem. All right, some other clauses to look out for. The indemnification clause. So these clauses essentially talk about who bears the risk. Obviously, if you're contracting with a software vendor, one of the things you want to be particularly mindful of is infringement for indemnification for claims by third parties that the software infringes on their intellectual property. But these days, if you're sharing data with a third party, you also want to expressly talk about who's carrying the risk if there's a breach, data incident or a breach event. And obviously, it's not hard to justify if they're safeguarding your data and they're making promises about the level of security and the incident happens at their facility or on their watch, then they should be responsible. Be mindful, however, of limits of liability clauses. So there are frequently in these software agreements clauses that say something like, in no event will our the software provider, our liability to you ever exceed, let's say, for example, the amount of fees you pay us in a prior 12 months. Well, licensing fees frequently are not that high. Let's say it's 10 grand, just to pick a number. Well, if you're not careful, then it's possible that $10,000 limit will also put a cap on their indemnification obligations in the event of a breach. And some of the prior webinars we've handled in this series, we've given you some sense of the cost of what it is to respond to a breach. And I can tell you 10 grand is really not going to cover it. So what you want to try to do is make sure that any limits of liability, if you want to agree to those business terms, you just try to make sure that that limit does not apply to the indemnification obligation. And you might also be on the lookout for a contractual clause that they carry cyber insurance of a particular type or limit. You want to try to get some specific information about their coverage to make sure you won't be relying solely on the pockets of the software vendor to pay out if there's any claims. Keep in mind, however, that you're not going to be their only client. They're going to have your data stored likely on some server farm. I'm just saying that if your data is compromised, it's very likely that many of their customers' data is compromised at the same time. And so you sort of have to think of the overall risk and the financial stability of the company you're partnering with. Can they really handle a breach event that involves many of their customers all at once? Because you're probably not going to be the only one. A couple more here. You want to make sure that they have to give you, by matter of contract, prompt notice of all incidents involving your data, not just breaches. Breaches have a defined meaning under many states' laws, and you want to know before they have to provide any notice under law so that you can get ahead of it and control the message and be involved. And be mindful too that, as we discussed last week, that consumers are getting more and more rights under privacy laws, and they need to be able to help you implement them. So if you get a request, for example, that from a consumer that their data be deleted, you need to be able to pass that along to the third party that also has a copy of that data or houses that data for you. They need to be able to implement that. And the things that Tom's going to talk about, you want to try to make them work their way into the contract as well. So I will turn it over here to Tom. Tom's going to talk about the next three sort of basic ingredients for vendor management policies.
So one of the things to look at here as part of your vendor management is, you have to have a policy, but you need to evaluate what do your vendors access with inside your network, and should they be accessing data within your network? Should they have that control or constraint in order to do so? If they are, how are they doing it? Is it through an FTP site? Is it through a VPN connection? Is it through some other sort of direct access into your network, or do you have to export data and send it to them? And then you've got to keep control of the export. Is it contractually necessary for you to be able to have this or provide this access to them to do their job? And how can you limit that? Once the vendors have your data, how do they segment it or separate it from other clients to make sure that it doesn't get commingled and cause privacy issues from your data versus their data versus other client data? And then if they are accessing and maintaining your data, what level of compliance is your vendor following to help ensure that they're doing the right things? Next slide. So the things that you want to be asking your vendors for is an updated vulnerability assessment, a risk assessment, patch management report, incident management report, things that prove, because it's in writing in a sense, that they're doing the things that they've told you in the contract or as part of a sales email or whatever it may be, that they're really doing the things that they told you they're doing, and they have proof in writing that it's being accomplished. Next. So you should have, when you have vendors that are accessing data or you're sharing data with or have access to your network, any of those things, you want to make sure that you're monitoring how the vendor is handling your data, and at least annually require the vendor to provide a series of policies and plans to show that as times change, that they're keeping things up to date and doing the right thing for you as a vendor, and they're protecting their stuff and your stuff too. So you need an information security policy, a risk management policy, a third-party vendor management policy. Just as you're auditing your vendor, they need to be auditing their vendors as well. An incident response policy and plan, a data security policy, physical security, business continuity, disaster recovery. All of these things kind of go together, and they should all be being reviewed on a regular, at least annual basis, to make sure that your vendor's doing the right thing. And then internal and external penetration testing and a vulnerability assessment. All of those things have to be done on an annual basis in order to show viability in the trust that you're placing in your vendor. And if they can't, to me, in today's world, that's adequate reason to look for a new vendor that's going to be able to do those things for you, and should be. Everybody should be doing this stuff. We are. Other people are. It's kind of the supply chain effect now. It has to go from creation to destruction. All of this stuff needs to be happening.
Tom, let me ask you a question. A couple slides back, you had sort of a list of these third parties, if you will, or the frameworks that vendors might adhere to. Can you give the folks a little bit of a sense of what it means to have a SOC 2, SOC Type 2 audit report, or how that process might work, okay, so they might be able to ask questions of their vendors about things like that?
So in the service management world, I used to run a managed service, an IT managed service company, and SOC 2 Type 2 was kind of the gold standard, or is a gold standard, for being able to say that we have policies and procedures in place to protect the services that we deliver to you in a repeatable, auditable format, and we can guarantee it, and it's been a third party authenticated to be correct, and you get a certificate saying that you're a SOC 2 Type 2, and it's good for a 12-month period under which you're constantly continuing to do the right things, but you're also being audited so that every 12 months you're being recertified.
And do you have a sense, Tom, about how expensive it is for the vendors to get those kind of reports and audits?
Depending on which direction or which compliant method that they want to use. So if you're a medical practice and you're working with a medical vendor, then HIPAA is kind of the thing they have to do, and they need to be audited on a regular basis, and it should cost them anywhere in the $20,000 to $50,000 a year range to make sure they're doing the right things. Whereas a SOC 2 Type 2 is a little bit more expensive, and you're usually in a six-figure range. SOC 2 Type 2 is very, very hard to get, but once you have it, it's very easy to maintain because you're doing the right things. Yeah.
So this might be an example. If you wanted to very quickly ask a vendor for sort of proof that they might be worth trusting, asking whether they've gone through any of these sort of certification or audit programs, and for proof of successfully passing the audit, such as certificates, might be a way to do that in a pretty easy ask, in other words.
Correct. One of the things to consider, and be careful of this, is folks will send you a SOC 2 Type 2 for their cloud hosting provider, and that doesn't really cut the mustard as far as doing the right thing. Your service provider and your cloud hosting provider both need to have SOC 2 Type 2. It's not just one piece of it. Has to be end to end to protect your stuff.
From the business interruption perspective, Tom, I mean, one thing that I've seen, particularly be a selling point is co-location, if you will. Mm-hmm. That where the vendor says, your data is in multiple places, so that if the internet goes down in North Carolina, we switch you over to the data center in Colorado. Can you tell folks a little bit about that and whether that's useful to be mindful of?
Well, it does fit into your business continuity plan, disaster recovery, and making sure that you stay up. And it's the responsibility of whoever your co-location group is to make sure that each location is following the same sets of rules, so that if you audit one, it's the effect of auditing all 2, 3, 4, however many co-location sites there are. It's a complicated process, and there are frameworks that you can follow for vendor management to help kind of put this all together and align it and create the lists that you need to in order to get this done for your company.
We had a question, Tom, come in that the question is a SOC 2 Type 2 enough or should all the other documents be provided as well? I think this is a question about the slide we have up right now with all these other things to ask about. But I guess the question is, can you shortcut that if they've got a SOC 2 Type 2 certificate?
You need to read the SOC 2 Type 2, and they should also be willing to provide all of these additional policies. If they've gone to the trouble to get the SOC 2 Type 2, they're a pretty open book. And for you to get all this other information should be just a simple request and you're done. You might have to follow an NDA or sign an NDA in order to get access to it. But people are pretty proud of their SOC 2 Type 2s. Yep. So it all goes hand in hand.
Right. So this slide here is, we've got one other question that came in that we'll get to in a second, but wanted to sort of pause a little bit and give folks an opportunity to type in any other additional questions. What we've tried to cover today is to give you a general sense of the growing risk. Again, these third-party vendors could be your weakest link. If you don't understand what it is they're doing, you can sort of undercut all the good stuff that you've been doing behind the scenes to protect yourself. So be careful. Tom was telling me a story the other day about, what was it, Citibank, Tom, that allowed their adjacent parking garage vendor access to their network, and they were a source of a problem for Citibank. So understand the risk. It's great to partner with these folks to provide good services to you, but in the world that we live in today, you've got to do some examination of them. So again, we're advocating for you to have a written plan to assess and monitor these risks. And we've covered some of the contractual clauses that you want to be on the lookout for. Again, the devil's sort of in the details with respect to that fine print. But when you're negotiating these deals, you've got to think of the sort of worst case scenario and how the risks are going to fall. And again, the sort of big takeaway is whatever promises they make regarding security, get them actually worked into the contract itself. So we had one other question here. It says, do you consider Expensify political email a breach of trust? Having access to end users' expense reports, I have lost trust in them respecting data as they used email addresses inappropriately. Well, I'm not familiar with their terms of use. I guess sort of one of the clauses, contractual clauses we didn't really talk about today is spelling out specifically what data they get access to and what they can use it for. I think in general, you want to try to clamp down as much as possible so they can only use the data in connection with providing you services and not sell your data to others or otherwise monetize your data. Tom, do you have any insight into these folks in the political emails?
This is one of those things where you get an end user licensing agreement at EULA, and you need to read the EULA. But I think if folks were to go back and read the EULA, there would be a reason why the 10 million emails went out. The 10 million Biden support emails went out to the Expensify users, if they were allowed to do it as part of their EULA. You know, there's a political backlash there because a for-profit company emailed it, but in reality, it's probably in the EULA. It says that they could.
Right. I don't see any other questions, but you have our contact information here. If you want to reach out to us, please feel free to do so. The slides will be available on our website too, so you should be able to access them. We hope to see you in a few weeks at our 5th and final. We had a thank you so much. So thank you for whoever posted that. We have our 5th and final seminar coming up in December where Tom's going to tell us a lot of scary stories right in time for the holidays. So that'll be terrific. So thank you very much, everyone, for joining us. We hope you have a great day, and we hope to see you in a few weeks.